46. How many of you actually believe the fact that there exists a terminology called as cyberspace? Is it really good to kind of talk about a particular term that probably was not in existence before? Do we have something called as cyberspace? I mean, is it actually a word? Because if somebody coins a word tomorrow, can we actually say that that was some word in English that was in existence from time immemorial? Because that's actually going to be coined tomorrow. I really believe that cyberspace is not actually a space. It's kind of a, what do you call it? It's kind of a portmanteau. I'm pretty much sure that all of you might have heard this term. Say, for example, there's always this particular question that people ask whether you had breakfast, and then you say no. And what's your next plan? You might say, probably I'll go for brunch. So it's kind of a mix of a breakfast as well as lunch. It's the same thing. Cyberspace isn't space. Cyberspace is not even a word technically. It's just that for the purpose of convenience, we kind of used it. That's all. That's all. So cyberspace technically does not exist, because at the end of the day, people who have learned information technology law, information technology act, people who have done at least a bit of readings on that, would definitely understand the fact that at the end of the day, you require something tangible to look at for fixing liability, for fixing responsibility or accountability. Say, for example, this is one particular question that's been asked generally in the context of information technology law, whether the Information Technology Act has extraterritorial application. So yeah, of course we can actually interpret certain provisions to mean that Information Technology Act has application even outside our Indian territory. But the problem there is, though this particular legislation could even be applicable against foreigners or non-citizens or non-residents or aliens, the fact is that at the end of the day, you require a particular computer or a computer resource or a computer network or a communication device or an intermediary to be there in India. So something that has happened to a system in India, something that has happened with the help of a system in India, should be there in the very beginning, so that you could actually talk about extraterritorial application. So something tangible at the end of the day should be there. So you talk about this not being a real world, this being a virtual world, but at the end of the day, you really require something tangible so that Information Technology Act could apply. This is what Section 75 says. So Section 1 of the Information Technology Act, read with Section 75, gives an idea, gives a holistic picture that extraterritorial application is there, but at the end of the day, you require some kind of a system or a computer or a network or a communication device in India. All right. Now, the reason why I brought the Section 75 at the very beginning is that your privacy could be violated not just territorially. Your privacy could be violated even by a person sitting outside India. So in that case, how do you fix liability? So the first question that comes to my mind is cyberspace. Do we have that kind of a space? I seriously believe that it's not even a word, it's not even a space, it's something kind of a portmanteau. Like I said, brunch, motel. So something that's been coined. Cyber was one word, space was another word, and we just combine these two words to mean this. Now, before I start moving on to the core area, I'm so sorry that I'm not able to share the screen. Before I move on to the core area, I really want this to be, thought from your end. This to enter all your minds. Okay, so I'm not really a fan of a particular judge that I'll be talking about. His name is Oliver Wendell Holmes Jr. All of you might have heard about this particular judge as well. There's a very famous quote he had made in terms of understanding what law is, and every lecture of mine, every presentation of mine would go in this particular idea. All right. The reason why I'm not a huge fan of this particular judge is because of certain judgments he has given. This has got absolutely no connection with information technology law or right to privacy, but I deem it appropriate to state this. There's a very infamous judgment given by this particular judge. That infamous judgment goes by the cause title Buck versus Bell, BUCK versus BELL, Buck versus Bell. It's connected to some other area. It's connected to medical law. So the judgment was basically this: the facts connected to this particular judgment was, or this particular issue was, that there was this one particular person who was slightly mentally challenged, mentally disabled, mentally handicapped. The next generation also turned out to be slightly mentally formed. The third generation happened to be the same. So this particular judge said, we are ordering forced sterilization onto the third generation person. Why? Because United States is fed up with mentally, incapacitated persons. Can we actually have forced sterilization, that too being ordered by a judiciary just because somebody happened to be mentally retarded? Remember, those times your mental capacity was actually being judged on the basis of the IQ test, which was not the proper test, right? Which is not the proper test right now. So I'm not a huge fan of this particular judge because of these kind of judgments. At the same time, thank you so much, ma'am. Thank you so much. Thanks a lot for sharing it. At the same time, I want all of you to understand the way in which you should be listening to this particular presentation of mine, and probably listening to all the classes being taken by the faculty members. Say, for example, his definition of law is something that has invited my attention a lot. Say, for example, he has defined law in this way: law embodies the story of a nation's development through many centuries. What is it? Law embodies the story of a nation's development through many centuries, and it cannot be understood as if it contains the axioms and corollaries of a book of mathematics. Law cannot be understood like maths. In order to understand what law is, one must know what it was, what it is, and what it tends to become. So I'll just explain a bit more. Probably I'll just take less than 2 minutes for that. Then we'll move on to the core area. But the definition is very simple. All of us had our mathematics professor or our arithmetics teacher in our 6th standard or 7th standard or something, coming to the classes and asking us to solve x plus y is equal to 7, x is equal to 4, solve y. You've heard this particular problem, right? Like, did any one of you, or did any one of your schoolmates or batchmates or classmates question that particular teacher, asking her, why should we believe that some x plus y can become 7? Because x plus y, that's an alphabet. 7 is a numeral. You add to alphabet, you're supposed to get. Why should we even believe what you say? Nobody perhaps would have done it. Nobody would have questioned that particular faculty, right? I did not question the faculty. Why? Because I took that for granted. I just believe that particular faculty. Law cannot be understood like maths. Law cannot be. That's what he said. In order to understand what law is, one must know what it was. How did x plus y become 7? What it is, and what it tends to become. So at least by around like 12 o'clock, the majority of the attendees here, so we have got somewhere around 53 participants here, probably that is including me and Vidya ma'am as well. So probably at least the majority, somewhere around 26 or 27 people should be at least able to kind of predict what the law in connection to virtual world, cyberspace, and right to privacy. You should be able to predict what is actually going to happen, at least in our country, by around 12 o'clock. That's the reason why I gave you this particular definition. You should be understanding law in such a way that you've understood what it was, you're trying to understand what it is, and you should be able to predict what is going to be in future. Good or bad, right or wrong, you should be able to kind of predict. Now, bringing in right to privacy in the cyber world, look at the slide that I've depicted here. Look at the screen that's been shared right now. Do we have an information technology which was framed with an intention of respecting everybody's privacy? No. Do we have Information Technology Act in India, which was created, which was codified with an intention to curb cyber crimes? No, that wasn't the objective. And to make matters more clear, our Information Technology Act does not even use the word cyber crimes. It uses the word offenses, cyber offenses. It uses the word cyber contraventions. So both these things could be different. Cyber contraventions could be different. Cyber crimes could be different. One set of wrongs could actually ask for compensation. One set of offenses could actually ask for imprisonment and fine. So these things vary, but my presentation is not on that area, so I'm not going to that area. But be rest assured that Information Technology Act was not basically framed with an objective of securing anybody's privacy, securing data privacy, or even to curb cyber crimes. That wasn't the objective. The objective was very simple. We had to be in tune with the international standards. We had to be in tune with what was actually there, the machinery that was there at the international level. So we had to respect the electronic commerce model law of the unseen truth. We had to respect that. So in order to facilitate smooth international trade, in order to facilitate e-commerce, in order to ensure the fact that the government records, electronic filing of documents happen with these government agencies, these were the basic three objectives why the Information Technology Act of 2000 was codified. Later amendments have happened, 2008 amendments have happened, which came into effect in the year 2009. I understand all that, I respect all that. But what's more important for us to understand is we did not have these as the objectives. Our framers' intentions were not this. So right to privacy being brought into the realm of cyberspace, into the context of Information Technology Act, it's always good to understand that wasn't there in their minds at all. All right. Now, yes, the next slide. Thank you. Can we have the next slide, ma'am? I'm so sorry that I'm asking you to do this, but if you, yes. I hope all of you can see this. It basically means very simple. All of us, almost all the Indians were in a state of shock when WhatsApp declared something that our data could be revealed onto their business partners. So the third parties could actually get our data. Now, whether they would get our data as such is a question. What they failed to make us understand was that it's not the data that would be shared, but it's the metadata that would be shared. Say, for example, tomorrow you're booking a flight through Make My Trip app or Yatra app or Goibogo, any kind of an application. And you know that even now you get your WhatsApp messages, the confirmation of your ticket, the PNR, everything that could be received through your WhatsApp as well. Now, the fact that you are traveling in this kind of flight, the PNR status is this, the number is this, your ID, that may not be revealed. That may not be revealed at all to any kind of a third party, including the parent company, Facebook or Metaverse. That cannot be revealed. That will not be revealed. What they meant was the metadata, the fact that you are interested in using applications that too for booking flights, that fact could be shared, which is called as a metadata. Say, for example, if you talk about an audio file, the song itself, the lyrics in that would not be considered as a metadata. That would be data. Metadata would be the genre to which that song belongs, the duration of that particular song, everything that is incidental to the main data could be considered as a metadata. So that would be shared, which itself is a violation of right to privacy. But I'm not on that point. What's the presentation topic? Is it a myth? Is it actually a myth to believe that you have right to privacy secure at least now? You had right to privacy secured before, or you would be having right to privacy secured in cyberspace in future. That's what we are trying to understand. Now, the reason why I have coined my term, the title of the presentation as a myth, the first reason is here. This was the latest message or the latest privacy policy of WhatsApp, wherein they specifically say that our data could definitely be shared with Facebook then, because that was the parent company then, the name was not changed to Metaverse. So it would be shared to Facebook and it would also be shared to any third parties. That created so much and so much of hue and cry. That created so much and so much of problem. What we failed to understand, was this. Can we have the next slide? This was the policy that was there that is there right now. What people fail to understand was that even before the updated WhatsApp policy, look at this particular policy. This was the existed policy then. Even before the update came, WhatsApp had made it so sure that our data, which we exchange through WhatsApp, may not be definitely shared with all the third parties, but it would definitely be directly shared to Facebook. If you can look at the last part that I've highlighted in green color, you would understand that. However, your WhatsApp messages will not be shared on to Facebook for others to see. Third parties may not be able to get it through Facebook, but Facebook gets it. In fact, Facebook will not use your WhatsApp messages for any purpose other than to assist us in operating and providing our services. So WhatsApp had made it so clear even before 2021 or 2020, or even before that, from 2012 or 13 or 14 onwards, WhatsApp had made it so clear that if you are using our application, by trying to understand or get an assurance from our end that your privacy would be secured 100%. No, that's a myth. We will not be guaranteeing you absolute right to privacy. Your data could definitely be shared to our parent company. The assurance that we could give is that it may not be shared to the third parties assets by Facebook. But right now, that has also changed. So it has become worse. I agree with that, but then I really did not quite understand as to why people were acting as if they were hearing it for the very first time in the year 2020 and 21, when WhatsApp said your privacy would be at stake. It was always at stake. It was always at stake. There could be a question from the attendees end that WhatsApp messages are end-to-end encrypted. So can we actually have a reasonable expectation of securing privacy? I'll come to that eventually. Before 12 o'clock, I'll definitely come to that particular area. Now, what exactly do you mean by right to privacy is what I've mentioned in my next slide. It does not require any kind of an explanation. I would definitely stick on to these 2 points. When somebody says about right to privacy, being on a real-time basis in the real world or being on the virtual world, two important things are there. One is your anonymity, and the other one is your confidentiality. If you really want your data not to be revealed to any other person, you talk about confidentiality. If you want data to be revealed to any other person only with your explicit consent each and every time, or say, for example, you have given blatant consent for a period of 1 year, on the expiry of that one particular year, if the data should be revealed in the next year, your explicit data should be taken by the data fiduciary. Now, the other important point is with regard to your identity. So even when you talk about messages being sent, you have encryption in order to ensure the fact that the message as such is not being tampered with. Somebody has not hacked into your system just to tamper the particular message. You have encryption, you have asymmetric cryptography, you have a system of public key and private keys being into operation and all that. That's fair enough. But in order to secure the identity, you have something called as a digital signature certificate. So anonymity is something that is so important when it comes to right to privacy. So I would definitely ask everybody to read Puttaswamy versus Union of India, which is a 2017 judgment. But my next slide would definitely point out to the fact that Puttaswamy versus Union of India was not just a judgment that kind of explicitly guaranteed to you right to privacy, but I would say Puttaswamy versus Union of India was a judgment that made it clear to all of us that in which all cases your right to privacy could be compromised or diluted. So Puttaswamy is a good judgment, it's a landmark judgment, it's a very famous judgment. So I say it with all respect that Puttaswamy versus Union of India has granted to us right to privacy. But Puttaswamy versus Union of India is not just a judgment known for that. It is also a judgment that has made us understand that your privacy could be diluted, could be compromised when there are certain tests that's present. Say, for example, if there is a law, if that particular law has a legitimate aim, if it actually satisfies the test of proportionality, in all these kind of cases, your privacy could be compromised or diluted explicitly by law, is what Puttaswamy has taught us. Okay. Now, there could be different kinds of privacy that we talk about. If you could actually go to the next slide, you'll understand that. You could actually have so many varieties of privacy. Say, for example, you could have bodily privacy, you could have spatial privacy. There was a point of time when you actually used to say there are only two sets of privacy. One is spatial privacy, what you have to do with your body, what not do with your body, and informational privacy, the data concerning you. But then, this is something that is worth understanding now. So you could have n amounts of privacy. You could have bodily privacy, you could have spatial privacy, you could have communicational privacy, you could have privacy related to your property, you could have privacy related to your intellectual property rights, you could have decisional autonomy or decisional privacy, you could have associational privacy, with whom you need to associate, with whom you need to mingle, you could have behavioral privacy, you could have various kinds of privacy. But it's all about understanding that at the end of the day, everything would definitely become part of your informational privacy. And when I talk about informational privacy, you really need to understand that informational privacy has got two connotations, a negative connotation as well as a positive connotation. Now, what do you mean by a negative connotation? Excluding you from accessing information related to me, That's a very positive right so far as I'm concerned, but so far as you're concerned, it's a negative right. So excluding you from accessing my information could be a negative connotation of this particular right called as an informational privacy. At the same time, when I talk about a positive connotation, it's my right to self-determination on my right to information as regards whether I would be granting you this particular information, or I would decide at the end of the day whether you can do something with regard to my right information. I'll give a very simple example. I'm not really sure as to whether anybody is entitled to respond in this particular session. If that permission is granted, if you think this is interesting, you may unmute and then participate. If not, we'll keep it towards the end. Up to you. What CMR says, please follow that. Now, when you talk about Twitter accounts getting blocked, when you talk about Facebook profiles getting blocked, who ultimately decides whether your account should be blocked? It's not you for sure. It's not you for sure. It may be the intermediary. It may be the intermediary, the social media intermediary, the significant social media intermediary, or even the government which decides for you, which is really, really unfair. That is actually another aspect of dilution of your right to privacy, but that's what an essential component is. Excluding others from getting your information is a negative connotation of your right. At the same time, when you actually talk about right to self-determination over this, you would decide what should happen to your right to information. That's a positive connotation on informational privacy. So we would be trying to analyze India's Information Technology Act and the things associated with that, connected to the negative as well as positive connotation on our right to privacy. Okay. Now, what I've tried to mention in my next set of PPT slides, there are a series of case laws. There are a series of case laws here. I'm not taking out my time to discuss all these case laws, but it's all about understanding that there have been various progressive judgments in India, mostly by the various high courts. There have been not so progressive judgments also. Now, the problem when it comes to most of the issues in India is that our courts, it's a very subjective opinion of mine, okay? You could always differ. Our courts may not be really consistent in going on with a particular approach. You would say that's the merit of an accusatorial system that we belong to. That's a merit of a common law system that we belong to. But at the end of the day, you really require some kind of consistency as well. Say, for example, when you look at Kerala High Court's approach towards right to privacy, yes, in Sprinkler's case, as you might have heard, Balu Gopalakrishnan's case, the High Court came to the conclusion that privacy of COVID patients should be respected in terms of getting their consent before giving this particular COVID data to any third party, whether it is a US based or an Indian based, you should require their consent. What the High Court also said was the data should be anonymized. I'm not really sure as to whether you've understood what I just said. Anonymization of data is generally considered as a good thing, because you pick the data, you cannot say whether that particular data belongs to Sandeep or Vidya ma'am or anyone else. The problem there is when you anonymize the data, there's a huge problem that's there, which people do not always consider. When you anonymize a particular data, the problem is this. Suppose my data has been entered into, Vidya ma'am's data has been entered into, the third party's, another person's data has been entered into. What if I want to withdraw the particular consent, I want to get the data back? Say, for example, talk about stem cells, talk about genetic research. I want to get my bodily part back. I want to get my stem cells back. I don't want to give that particular consent perpetually. I want to get it back after 1 year. If you have already anonymized the data, then how can you know whether that particular thing belongs to Sandeep or Vidya ma'am or someone else, X or Y? So if you anonymize the data, that necessarily may not be safeguarding all your rights. Privacy would be safeguarded, but privacy is not just everything, right? I do have a question to all the attendees here. If you have time for discussion, it's a very simple question. You might actually believe that I'm stupid if you have not believed that till now. The question is very simple. The question is this: I want all of you to kind of think before you answer. Which is the provision in the Constitution of India from where you could actually trace right to privacy? Okay, after Puttaswamy's judgment, I want this answer. Are you allowed to speak now or later? Okay. If you're allowed to speak now, please unmute and speak, or else we'll just discuss that later. My question is very simple. Like I said, like I asked, which is the particular constitutional provision, the article that we have that talks about right to privacy now after Puttaswamy. Okay, that's a question. You want me to wait for a few seconds?
Dear students, you can unmute and you can.
Oh yeah, thanks for the permission granted. Yeah, it's a very simple question. So I think anybody should be at least volunteering to kind of answer at least this. It's a very simple
Article 21.
Sorry.
Article 21.
Article 21. Thank you so much for saying that. I'm so sorry because I cannot kind of collect your names and all that because I kind of goofed up the entire presentation. I know that. So thank you so much for saying that. Yes. Any other answers that I'm any other answers? Which is correct. Which is correct. There may not be any other answers, but still, any other answers? Okay, I do have a connected question. So before going on to the judgments, I want all of you to understand this. Okay. Thank you so much for saying that answer. You have heard about some right called as right against self-incrimination. Have you heard it? Can somebody say yes or no? Right against self-incrimination. Like third-degree methods cannot be used. Nobody can be compelled to give evidence against themselves and all that. That's there, right? Article 20, clause 3, if I'm right. Correct? Now, when you talk about right to privacy of an accused, when you talk about an accused right to privacy, an accused should not be compelled to give evidence against himself unless and until he consents. So he cannot be compelled to testify against himself. When you talk about an accused right to self-determination, right against self-incrimination, that comes under Article 20, clause 3. Where is that accused right to privacy? Can somebody tell me? Where is that accused right to privacy? Is it only there in Article 21? Is that what Puttaswamy said? Now, the person who gave the answer, you're absolutely right. You're spot on. I'm just trying to give an additional picture and another side to it. That's all. Doesn't mean that your answer was wrong. Your answer is correct. Your answer is correct. Probably your faculty members might have also said the same thing, which is correct. But Puttaswamy's judgment, if you read it in detail, the positive side of Puttaswamy judgment is this: right to privacy is part of right to life or personal liberty under Article 21. But the judgment doesn't stop there. The judgment also says that it is implicit in almost all the rights under Part 3. So if you're asking me a question whether right to privacy is there in Article 20, clause 3, it is there. It is there in Article 20, clause 3. So far as an accused right against self-incrimination is concerned, that has become a part of right to privacy, which is not just there in Article 21, which is also there in Article 20, clause 3. Look, talk about a particular person's right to abortion, female reproductive autonomy. It is there in Article 21, right to life. It is there in personal liberty. It is also there in Article 40. If you talk about right to abortion being granted to one person, not being granted to another person, both of them being similarly placed, it is there in Article 14 also. Similarly, it is there in Article 15. Somebody is being discriminated. Somebody's data is being given, somebody's data is not given. Discrimination. Article 21 read along with Article 15 as well. So I'm not talking about the typical Maneka Gandhi's just, fair and reasonable thing. I'm not talking about that. It is implicit in all the aspects of fundamental rights is what we have to understand. So that big is the right theoretically. Practically, there could be problems. So yeah, coming back to the other thing, thank you so much for participating. It gives me an understanding that people are still listening, though I cannot see anybody. And you could have other judgments by the Kerala High Court also, Shireen versus State of Kerala, where they actually said right to internet access for expressing your freedom of speech and expression. That is also a fundamental right, because that's being kind of categorized as a human right. I wouldn't necessarily say that right to internet has been categorized as a human right, because when you read those particular United Nations General Assembly resolutions, you'll understand that through right to internet, yes, that has become a human right. That is a fundamental right. Shireen versus State of Kerala. Now, I have this interesting point to kind of make here. The difference between any kind of attitude of the Indian system vis-a-vis the foreign system is this. This happened during the iPhone 4 or 5. Not we talk about iPhone 13, iPhone 13 Pro, and all. This happened when it was iPhone 4 or 5. You know, there's this gang wars in the United States. So in one instance, what actually happened was the particular criminal got killed by the police officers, by the FBI. But his mobile phone was recovered, and that happened to be an Apple iPhone. So FBI wanted Apple to decrypt the entire information that was there in his phone, right? So they actually challenged Apple's decision, because Apple said, no, we're not going to do that. And so they challenged this particular decision in a court. And the court of law did say that they did oblige, so they did want Apple to kind of decrypt the particular information. You know what Apple did? Apple came out to the public and Apple said, we had promised you right to privacy. The judiciary as well as the executive is trying to force us to decrypt this particular information. We will not do that. We will not decrypt your information at any particular cost, even if it is to investigate any kind of an offense. This is what Apple said. And ultimately, FBI managed to get it decrypted to a third-party private person. People say that was an Israeli, but they managed to get it done. But this is something that Apple respected. Everybody's right to privacy. But if you look at a very recent Karnataka High Court judgment, if you can go to the next slide, the judgment is Virendra Khanna versus State of Karnataka. In Virendra Khanna versus State of Karnataka, there was a next slide, ma'am. That's a very interesting but ridiculous observation. The High Court of Karnataka said, if you're an accused and if the investigating officials want to get some data from your laptop or computers or your phones, there is absolutely nothing wrong if you deny your passcode or biometrics or something. If they cannot access that particular information, there is absolutely nothing wrong in getting that decrypted from a third party. So forceful decryption of data could be done, is what Virendra Khanna versus State of Karnataka said. Now, it is up to you to decide whether it is right or wrong. If you're too much into respecting your right to privacy, it's time that people rethink about this particular decision. Why? Because look at what happened in US. Apple said, no, once we have given a promise, we are not going to, fall back on the promise. But then, so we are not going to kind of, take back that particular promise. But when you talk about Virendra Khanna versus State of Karnataka, what was interesting to note that you could have right to privacy compromised, especially even with the help of third party. So the investigating officials can ask any X or Y to decrypt the particular information that has been stored in your records. Interesting, right? Now, if you go on to understand whether right to privacy is secured, if you go on further, if you can just go on to the next slides, very quickly, we'll just try to rush through the slides because I don't have too much of time. We have different rules that exist at different points. Say, for example, we had this 2011 rules at one particular point of time. If you look at the next slide, rule number 6, I've specifically highlighted something. Now, nobody has to understand this set of rules right now, because 2011 rules may not be having any kind of application once the PDP bill, or like we call it right now after the Joint Parliamentary Committee's recommendation, the data protection bill. It was personal data protection bill. Now the word personal would probably be omitted, God knows. So data protection bill, when it is in force, if it comes to force, then 2011 sensitive personal guidelines will not have any set of force. But it's always good to understand the fact that there existed something called as the 2011 rules. If you look at it, whenever matters connected to your sensitive personal information, which means your financial data, your credit card data and all that, there is right to privacy, which means that your consent is so much required before it gets divulged to any other party. But if the government wants, something that I've highlighted in green color, if the government wants to have your sensitive personal information to be obtained by any of its agencies, then you do not have right to privacy. Whenever the government steps in, your right to privacy is at stake. Now, people would definitely tell me that it's your national security that is more important, your sovereignty and security of the country that is more important, your friendly relations with the country that is more important. I do agree. There have been judgments by the Supreme Court as well. A.K. Roy versus Union of India. Every words that are used in criminal statute should be used with absolute clarity, except for certain words such as security of the country, sovereignty of the country, because it's very hard to define. But the interpretation, you should be very strictly interpret that. Liberal interpretation should not be given to that. Now, that's not my problem. My problem is this. Every time when the government steps in, your right to privacy gets diluted. Okay, but the problem is the government can even dilute your right to privacy, get all sensitive personal information, even for investigating an offense. For preventing an offense, you can see that it's me highlighting the green color. I'm just trying to look at my laptop for the clarity. Preventing an offense, detecting an offense, investigating an offense. So if there are any cyber incidents, even for detecting or preventing in advance, they could actually have your right to privacy over your own sensitive personal information compromised, which is not at all a good thing. Now, the next slide would give you an idea regarding the latest 2021 intermediary rules. The The intermediary guidelines, they call it. The next slide has correctly pointed out that the government wants to identify the first originator of a particular message. Say, for example, imagine you are the first person who is circulating a particular, who has created and circulated a particular message, which the government thinks is against their national interest, national security interest. You're the first person who has sent it. Lakhs and crores of people might have forwarded that particular message. Government wants all the intermediaries to have sophisticated automated tools by which they can identify who the first originator of that particular message was. If you got that particular message from a foreigner from abroad, but you happen to be the first person who has circulated that particular message the first time, you become the first originator of that particular message. Now, what do you mean by encryption then? Anytime you try to WhatsApp a particular person for the very first time, say for example, if you have my number and then you try to WhatsApp me, if you're doing it for the very first time, you get that particular message on top. What is that? End-to-end messages are encrypted, right? That's the message that you get. But if it is encrypted, your data is protected, your security, your identity also should be protected. But the fact is that when the government wants any kind of intermediaries to identify the first originator, they can do it. That's what Rule 4 says. Rule 4 clause 2 specifically says that identification of the first originator is possible. Now, what's the kind of security that we talk about? Do we have right to privacy guaranteed right now? There are so many problems associated with a provision that enables the government to identify the first originator also. Say, for example, if you are the person who is a whistleblower, whistleblowers need protection. Journalists need protection because journalists need not always say from which source they got this particular information. But if the first originator is being traced, then you're revealing who the whistleblower is. You're revealing from which all sources did the journalist get this particular information. So much of problems associated when you dilute right to privacy. Look at this particular clause, Rule 4, Clause 4, which is there in the next slide. We had so much of case laws by name Shreya Singhal and all that. I'm not going there. One thing was for sure. Say, for example, if there is a defamatory material against me, Sandeep, in the online web page, I would be the first person who would want to take it down, right? Now, what will I do? I will send a mail to Google. I'll send a mail to this particular intermediate, Google India, as well as the parent company, Google US. Do you think they'll respond to my request? If they do not respond to my request, can I go to the court saying that Google is not taking my material down? The problem is Google might be getting billions of requests via mail every day, expecting them to read all these particular mails and assessing whether this particular material is a truth or in fact a defamatory material. That's very difficult for them because they don't know me. They don't know my background. They don't know what I've done to this particular world. So after Shreya Singhal's judgment, Avinash Bajaj and all that, Google versus other case laws, Vikas, I think there was another case laws as well. Now, the court came to a particular conclusion that on an individual person's request, an intermediary need not take down a particular defamatory or an obscene material. If there is a court order or if there is a government order, then they take it down. So we had that clear. Now look at what Rule 4 Clause 4 says. Rule 4 Clause 4 specifically says that in case of any kind of a sexual abuse content being posted, in case of anything that is defamatory that is being posted, then you should respect freedom of speech and expression. At the same time, intermediaries should have automated sophisticated tools that would actually identify the information that is there in the web and automatically take it down. So your freedom of speech and expression, as well as creating a responsibility on the intermediaries to take down everything that they think as offensive, that cannot go together. That cannot go together at any particular cost. So even if you look at the 2011 rules, even if you look at the 2021 intermediary guidelines, there are so many provisions that would in turn dilute your right to privacy. Look at the next incidents. Twitter, closing down all the accounts, internet shutdowns that happened. The biggest problem with regard to internet shutdown in India, everybody expected Anuradha Basin to be a very landmark judgment. Anuradha Basin was defeated. The problem is Anuradha Basin's judgment specifically said, you go for internet shutdown under the provision telegraph rules, that is fine. You have your own review committee. The government constituted review committee should at least be reviewing the internet shutdown measures after a period of 7 days periodically. The first review should happen after 5 days, periodic reviews every 7 days. That is what the court said. The court did not say that internet shutdowns cannot be there. The court said, let that be reviewed. What happened after Anuradha Basan judgment? An amendment was made to the 2000 in the year 2020 to the rules by which the government said, we are not actually going to review periodically after every 7 days. We are going to review it after a period of 15 days. And after Anuradha Basan, there have been many more internet shutdowns than in India than it was before Anuradha Basan. You know what the problem is? This is something that everybody should understand. Everybody says Anuradha Basan judgment, the proportionality principle was applied and all that. You should understand. You should understand. In Anuradha Basan, the court referred to two principles. One was the proportionality principle which existed in Germany. The other one was the kind of proportionality principle which they called it Oakes, O-A-K-E-S, Oakes doctrine in Canada. We refer to both. We modified the German version and then we applied in India. Do you know the dangers associated with the German principle? Like we say, we don't borrow. India doesn't borrow. We were inspired by. From basic structure, we were inspired by is what we said. We never borrow because that's an insult to us. So we were borrowed by proportionality principle of Germany also. Basic structure also which actually borrowed from Germany from the eternity clause, if you know that. Yes. Now, proportionality principle, there are two ways in which you could look at. Anuradha Basan specifically said, look at this particular part. The third point that I've mentioned here, there exists no less restrictive alternatives. So when the government restricts your freedom of speech and expression, when the government restricts your right to privacy, what should the proportionality principle do? The proportionality principle means whether there existed any other measure by which this restriction could have, whether there existed any other method by which this restriction could have happened, least restrictive measure could happen. German proportionality principle specifically says, if you have another measure which could restrict your privacy, which is lesser restrictive than this, that should be employed. That should be employed, beneficial to the public. But that least restrictive measure should be equally effective. So if plan A is in challenge, if you could prove that plan B was there, which was least restrictive, but if plan B was not equally effective like plan A, then plan A is in force, plan B cannot be resorted to. That is the problem with German proportionality. Least restrictive measure which is equally effective. Canada does not have that. India went for a modified version of German principle where luckily we don't find equally effective ones. But the fact that we borrowed German proportionality principle is always a threat to us. It's always a threat. I do have something more to actually talk about internet shutdown, but I'll go to some other provisions right now. If we can skip a few slides and go to interception and surveillance, it would be helpful. Say, for example, if you look at the Information Technology Act, we have certain provisions that dilute our right to privacy. One is Section 69. Section 69 specifically empowers the government. Yeah, here. Specifically empowers the government. Explicit provision on the face of it in the Information Technology Act. The government can intercept, the government can monitor, the government can decrypt any information whenever they want. So basically, they can direct any other intermediary to intercept the communication, to decrypt the communication, and to monitor the communication. 69A makes it worse. By virtue of an amendment, it came. 69A specifically says, rather than in addition to intercepting, monitor, or decrypting the information, the government can block access. Say, for example, if you have a Twitter account, you would be the last person to know if 69A is applied. If your account is blocked, everybody will get to know. The government would have done it. Intermediary would be helping the government to do it, which means Twitter would be helping the government to do it. Public would get to know that your account is blocked. You would be the last person to get to know about it. So 69 and 69A, always remember, interception, decryption, and monitoring in one provision, blocking access in another provision. The government is free to do that. And if you look at the kind of grounds that's being mentioned, it's really surprising. If you can just go to the next slides, I can probably clarify. I can probably clarify that. Section 69. Next slide, if I'm right. It specifically says that government could intercept your information, government could monitor your information. Next slide. Government could decrypt your information in the interest of national security, sovereignty, and anything, even for next slide, even for investigating an offense. Even for investigating an offense, even for preventing incitement to the commission of an offense at a very preventive advanced stage itself, The government could, block your access. The government could monitor the information. The government could decrypt the information. There are two rules associated with Section 69 and Section 69A. 2009 rules regarding 69, 2009 rules regarding blocking your access, 69A. You read both these two rules. These two rules specifically say the government can specifically order an intermediary to monitor the information, to decrypt the information, to intercept the information, to block your access, which could be a confidential information. Even you will not get to know that. It's a confidential information. And the records, so the government instructing them to destroy, government instructing them to monitor the records, that particular instruction, that particular documents, confidentiality should be there, and those particular documents, if not required further, should be destroyed within a particular period of 3 months or 6 months. Look at that. Your right to privacy is at stake, but government's right to privacy is protected. Government ordering an intermediary to decrypt, intercept, monitor, block access, all these things should be kept confidential, and it should be destroyed after a particular point as well. So even for the simplest reason of preventing an incitement to an offense, the government could violate your right to privacy. Now, this is slightly atrocious so far as a particular person who would want his privacy to be respected is concerned. Now, if you go on to another dimension, Vidya ma'am, am I allowed to take 10 more minutes? After that, if there is an opportunity for discussion, we'll do that. Can I do it?
Sure, sir.
Yeah, okay. Now, another dimension that I would want all of you to understand is right to privacy has got different aspects. When it comes to data, you call it data privacy. When it comes to prohibition of surveillance, we call it data valence, data surveillance or data valence. And what is really, really important, right? Okay, ma'am, I think I lost the, yeah, I'm so sorry, I clicked somewhere. So if you actually talk about, your, just a second. Yeah, okay. When you talk about another fundamental aspect of your right to privacy, it is called as a right to be forgotten. I really want all of you to actually, have this as one of the most important takeaways from my presentation, if not other things. I hope this would eventually be clarified, or this would eventually be sorted out by the government. We have so many judgments regarding right to be forgotten. International level, we have Spain judgments and all that. I'm not going to that area right now. I have all these things. If the slides are required, Vidya ma'am has that, so you could get it from her. Now, when it comes to India, the problem is again consistency is something that is left. High Court of Karnataka saying if an accused name comes in the judgment, that should only be retained in the court's records. In Indian Qanun and in public and all those things, your name should not appear if you think that affects your right to privacy. Say, for example, you are accused of an offense, and even 20 years later, somebody can easily identify the fact that you were an accused, because Indian Qanun would give that particular judgment where your name is there. So Karnataka High Court has said that no, it is not required. At the same time, see, Gujarat High Court has specifically said that even it's fine even if your name is there. So the slide that is being shown right now is the Gujarat High Court judgment. So if Indian Qanun depicts your name in its judgment, which has been authorized by the court, there's no problem. There's absolutely no problem. If you look at the Karnataka High Court judgment, next slide. If you look at the Karnataka High Court judgment has respected your right to privacy. Your name should not be there in the judgments in Indian Qanun. It should only be there in the court records as well. So you have so many match and mismatches there. So that's not what I'm trying to actually point out. I really have something to say regarding right to be forgotten. But before that, let's try to also understand whether there are any provisions respecting your right to privacy in the Information Technology Act. There is one particular provision by name Section 66E. Section 66E, the reason I'm smiling is because you could say that it is a particular provision that respects your right to privacy, but not in the context in which we were speaking. I think it's in one of the slides. Yeah. Punishment for violation of privacy. That the context in which privacy is protected and secure under Section 66E, that's an entirely different footing. Look at this. Whoever intentionally or knowingly captures, publishes, or transmits the image of a private area of it. We are not talking about data privacy. We are talking about some kind of a spatial privacy, where you reasonably expect privacy when that is breached. That is where section 66E, come into application. Okay, so IT Act by itself, whether we have right to privacy guaranteed, I doubt. We have some other provisions also where confidentiality of information, if it is breached, if there's a breach in the confidentiality of information, that's being punished. But that's not really sufficient. We'll go to the most anticipated one, PDP bill. So I've still mentioned that as 2019 PDP bill because I would want to have some kind of clarity as regards whether the Joint Parliamentary Committee's recommendation would be accepted in toto, what all are the discussions that's going to happen, and given the current trend, whether there will be discussion at all in the first place. I would want to actually know that. Two important things that we would want to understand: if you are the particular person whose data is being sent across to another person, you become the data principal, and the other person will be getting that particular data would become the data fiduciary. Okay. Next slide would give you an understanding as regards what a significant personal data is and what you mean by a significant harm. Look at it. The PDP bill talks about two kinds of harms. One is a harm, the other one is a significant harm. What do you mean by significant harm? If it has an aggravated effect, this is a problem. When you actually talk about certain kind of statutes, especially statutes that have provisions where penalizing certain breach or wrongs or offenses, you would want utmost clarity. Significant harm, you require clarity there. And for giving clarity, the another word that is used is aggravated effect. What do you mean by aggravated effect? That's a problem. Section 66A of the IT Act was declared as unconstitutional in Sharia Singhal because of that. If you post a message, if that is highly offensive, if that is highly menacing, if that is grossly offensive, if that causes annoyance, hatred, enmity, ill will, if that causes inconvenience, then you would be punished. This was what section 66A said. Inconvenience is a very arbitrary term. It could be interpreted any way. So the court said we are not reading it down, we're declaring it as unconstitutional because any other message could create any kind of inconvenience to another person. Doesn't mean that you should be arrested and sentenced to imprisonment, right? So aggravated is also some kind of a term. So for understanding what a significant harm is, you're going for another abstract term by calling it as harm that has an aggravated effect having regard to the nature of personal data being processed. So that's very tricky. It's very tricky. Now, going on to the next slides, prima facie, when you look at it, or initial provisions, when you have an idea, you will think that PDP Bill 2019 secures your right to privacy. See this: data fiduciary shall not retain any personal data beyond that period necessary. But it is all personal data. It is not data. It is personal. Notwithstanding anything contained, the data fiduciary may retain, provided the law says that or the data principal has consent. Look at the next slide. Next slide is that particular important one that actually says that your privacy is protected. What does the next slide say? That's the next provision actually. It's section 11 specifically says that every data fiduciary shall give to the data principal a notice. The data principal should be informed that your data is being collected, the data is being processed. You have a right to withdraw the consent at any particular point of time from where you have taken this particular data. If your data has been manipulated, you can go to this particular authority for expressing your grievance. This is the way you have to file a complaint. This is the authority where you have everything is secured. So this particular provision, I think it's section 11. That's a fantastic provision. So PDP bill should be appreciated because data principals consent. A notice that should be given to data principal is taken care. Problem is here. Section 12, there is a bigger problem. What is the problem? Again, data principals notice, consent, or data principal should not be even asked before processing the next slide. Data principal should not be even asked if there is a law, if the state wants to get that particular data, if the law wants to get that particular data, if there is a judgment by the court that says that the data is required, if the public interest outweighs your individual interest, your consent should not be taken. Look at the next one, section 14. Section 14 specifically says without obtaining consent. Next one, without obtaining consent, your data could be collected without obtaining. And why do we have this PDP bill then? In addition to the grounds referred to under sections 12 and 13, the personal data may be processed without obtaining consent under section 11 if such processing is necessary for such reasonable purposes as may be specified by regulations. Regulations are yet to come. Unless and until these regulations come, we will not understand what they've said. After taking into consideration the interest of the data fiduciary, whether the data fiduciary can reasonably expect to obtain consent, any public interest if it is there, what exactly is the effect of processing this particular data on that data principle, we require these regulations. Until and unless these regulations are there, we really cannot understand that. And if you look at this, what do you mean by these reasonable purposes? When it is necessary for reasonable purposes, consent of the data principle is not required. What is reasonable purposes? Next slide will give you an idea. Reasonable purposes would actually mean these things. For example, reasonable purposes would actually mean prevention and detection of any unlawful activity. Again, for preventing any crime, your privacy is secure, your privacy is diluted. Prevention and detection of any unlawful activity, including fraud. Mergers and acquisitions, whistleblowers, network security, debt recovery. I mean, the problem is this: when you think that, when you're about to think that your privacy is secured, personal data is secured, data privacy is secured, data valence would not be there, immediately other provisions would come by which it says that if it is for securing the interest of the public, in vague terms, your right to privacy is at stake. This is something that I really want to tell. Next slide, section 18. What does section 18 says? Right to correction and erasure. This is the next question that I have. The right to correction. Can we have the next slide? Right to correction and erasure. Section 18 says, if you do not want your data to be existing in the virtual world, you could actually have right to erasure. You could ask the data fiduciary to erase the particular data. If the data fiduciary says no, you could have actually recourse to appropriate authorities and complaints authorities. That's a different matter. So right to erasure is secured, right? Right to erasure is there for you. If you don't want your data to be there, that data would be erased. Absolutely fantastic. This is what section 18 says. Now look at the next slide, section 20. Section 18 says right to erasure. Section 20 says right to be forgotten. Right to erasure in one provision, right to be forgotten in another provision. That's complex. Where did we borrow this? Where did we take this? We took most of the provisions of PDP bill, including right to erasure and right to be forgotten, from GDPR, European Union, GDPR. GDPR in Article 17 specifically combines right to erasure and right to be forgotten. There is no confusion there. Right to erasure also means right to be forgotten. Problem solved. In India, we have created a further confusion. Right to erasure in Article 18, right to be forgotten in Article 20. I'll justify why there is confusion. A right to be forgotten actually does not mean right to erasure. Right to be forgotten means your data is already there with the data fiduciary. If you do not want the data fiduciary to continue disclosing that particular data, that is what you mean by right to be forgotten. Say, for example, you have a Facebook account, you're dead right now. The account, the data remains there. You don't want Facebook to disclose that particular information anymore because you're dead. Your relatives don't want that. That is right to be forgotten. Right to erasure means your relatives want that particular data entirely to be deleted, not even to be stored anywhere in India or elsewhere. Did you understand? So there's a problem there. Right to be forgotten should be equivalent to right to erasure. If you don't want the data to be disclosed in future, why retain that particular data by a third party? Now, that's not just the problem. The problem comes here. Look at the next slide. If you are talking about right to be forgotten, I think next slide. If you are talking about your right to be forgotten, next slide, ma'am. Yes, this one. If you're talking about right to be forgotten, where should you go? You should actually go to an adjudicating office appointed in the same act. If you're talking about right to erasure, you're not going to an adjudicating officer. If you want to erase the data, if you want to erase your data from a particular website, what you do is you approach the data fiduciary directly. You send them a mail. They'll do it for you because there are consent managers being appointed. You apply to them. They would probably delete your data for you. But if you want the right to be forgotten, preventing them from disclosing the data, you don't apply to them directly. You go through another channel. You go to an adjudicating officer. First, the adjudicating officer should be appointed. If the adjudicating officers are not appointed by the Data Protection Authority of India, if the Data Protection Authority of India is not just appointed, that's a problem. If the adjudicating authorities are appointed, you do not have right to be forgotten, but you have right to erasure. Article 17 GDPR makes it very simple. Right to erasure, right to be forgotten, everything included under Article 17, you apply to one authority and only one authority. No, they are not making it complex. Okay. I do have something more to discuss on PDP bill, but I'll skip to sections 35 and 36. Having said all this, that you might have right to privacy secured under the latest PDP bill or the Data Protection Bill of 2021, let's talk about section 35. I think it's the next slide. Again, interference by the government, right to privacy. See, power of the central government to exempt any agency of the government from application of the act. So, in the interest of security, sovereignty, for preventing incitement to the commission of offense, for public order, which is a term that has created so many problems in India. In all these cases, the government will not be bound by the provisions of this particular bill. Right to privacy is a joke so far as government is concerned, or is what my impression is. Look at the next slide, section 36. Section 36, you should understand. Section 35 and section 36, this is going to be the biggest takeaway so far as the attendees are concerned. Section 36 also follows the same thing. Section 35 says the agency of the government need not follow the act as such. Section 36 specifically says exemption of certain provisions for certain processing of personal data, for detecting a crime, for investigating a crime, for preventing a particular crime. You cannot claim right to privacy because none of these provisions would be applicable to those agencies. If there is a court order, your right to privacy is so much and so much of cases which have been identified by. That's a problem. So I think I'll just conclude by saying something. Ma'am, can we just go through the next slides? I just want to give a picture to all of them regarding how much has been discussed at the international and national level regarding right to privacy, but still there have been problems. 92, yeah, it's a beneficial provision, but let's wait for the government to finalize all these. Yeah, you could have data privacy, you could have data violence. Now, just go a bit forward, ma'am. I'm so sorry that I'm asking. Look at this. UDHR has got provisions regarding right to privacy. ICCPR has got provisions regarding right to privacy. If you go further, you'll understand more. Ma'am. Yes, you have the International Convention on Rights of Migrant Workers, 1990, having right to privacy. CRC, Convention on Rights of Child, has got provisions regarding right to privacy. Next one, Conventions on Rights of Persons with Disabilities have provisions regarding right to privacy. You have ECHR, very famous provision, Article 8, right to respect for private and family life. There have been, I don't know, enormous amount of judgments in ECHR regarding that. If you go to the HUDOC database in COA website, you'll get enormous amount of judgments there. Inter-American Convention on Human Rights, Article 11 talks about right to privacy. African Charter on the Rights of the Child talks about right to privacy, specifically with regard to personal information, personal data exchange, whether cross-border, cross-boundary exchange of personal data is possible, whether right to privacy can be there. We have got a 1981 treaty of the COE, Council of Europe. We also have the OECD guidelines regarding data privacy and cross-border exchange of data. We have all this. We have all this. National level, we have the PDP bill. I did tell you the provisions, if at all there are, that exist in the IT Act. But you know the problems at the end of the day. Why do you think it's a myth? Why do I think it's a myth? It's a myth because of certain things that have actually happened at the international. These are not hypothetical incidents. These are real life incidents. When a particular person who was about to be graduated, just days before she was about to be graduated, she was attending classes in a university in US, and she was going to be teacher. She was a teacher to be. They were just days before she would have graduated. She would have been graduated as a teacher. Days before that, the college authorities found a particular picture of her with a comment posted by her in a social media website called as MySpace, which was very popular before Facebook came. She had posted that particular picture. That particular picture had some kind of that picture was something which she was consuming some kind of drinks or something in a party. Now the college actually felt That's really, really, really bad so far as teaching professionals concerned. No, you have that. You have that. I've heard from scholars in India saying that your WhatsApp, display picture should also match your profession. I don't believe that, but then still. So this could possibly happen in these, what I'm trying to say. So because of this particular profile picture or any kind of a picture that was posted, that was uploaded by herself in a social media web page, she was not allowed to graduate. She was not allowed to become a teacher. She went to the court, but of no avail, because the court said there's no public matter involved here, so we are not talking about any kind of amendments, First Amendment rights. This is not a public concern; it's a very private concern. She couldn't get any kind of help from the college authorities and from the court just because of a particular picture that she posted online. Look at the next slide. There was so much of incidents. Somebody just posted the fact that I'm bored of my job. Just because that was posted, that particular person was thrown out of the employment, not profession. Migrants cannot cross over to certain boundaries. Why? Because of their social media statements. Say, for example, you have used drugs. You mentioned that somewhere. You cannot migrate to another territory just because you have used drugs and you have mentioned that. Recruiters, employers spy on your web pages just to know whether you should be hired or not. So your qualifications perhaps do not matter. Your attitude, your body language, what you will do in your personal life does matter. There are surveys that actually proves that. What you wear, if you do not have too much of money, you only wear two kinds of t-shirts or jeans, that could also be noticed by a particular person, just because of the fact that right to privacy is not actually secured. Let me just conclude by telling you this. In real life, you know what the advantages are? In real life, people forget. You make a mistake, real life, the real world gives you an opportunity to repent and to kind of, correct it and proceed in your life. Because people tend to forget what you have done. Nobody is there to constantly remind people the past mistakes you have done. Forgiving forgiving happens because people forget. That's what people say. The forgetting is part of forgiving. So in real world, you have that. Do you think about the past mistakes people have done to you all the time? No, you forget and you forgive. But in the virtual world, if at all there's a space called a cyberspace, like I said at the beginning, it's a portmanteau. So in cyberspace, that opportunity is not there. You are constantly reminded of your bad deeds or past deeds. Say, for example, in Facebook, I'm not on Facebook now, I was there. So it reminds you, right? It reminds you of the photo albums of the anniversary and all that. Maybe some pictures that you might have forgotten, maybe some people that you might have forgotten, maybe some incidents that you might have forgotten. It constantly reminds you. So you don't have an option to be forgetting things, right? To be forgotten is not exactly there, because of which forgiving is also impossible. Forgiving is impossible. People need not correct themselves. People may think that it gets reminded every second and every minute. I'll just be the same what I am. So that's the problem with not having an exact absolute right to privacy in the cyberspace. So I think I'll conclude with this. Apologies from my end once again. This has never happened to me when my laptop doesn't work. A new system given by the institution, but I really do not know what happened. Apologies from my end to ma'am, as well as to the particular person who introduced me. I think he might have introduced me more than twice. I'm so sorry that I made you do that. Apologies to all the attendees as well, because I kind of moved up a bit initially, but I hope the presentation was useful. Any kind of questions, any kind of comments rather than questions, any kind of comments or observations, you're welcome, because there could be so many persons who might give importance to the national security over right to privacy. I do understand that. Especially when you talk about terrorism and all that. That's really required. And so right to privacy, the concept of right to privacy is actually being so beneficial to terrorists as well, because there's nothing called as data violence here, or because there is no sophisticated tools for data violence here. Terrorists also get the benefit. Right. So right to privacy, when you talk about the benefits, there are dangers also. Right to privacy granted to a normal person is as good as right to privacy being granted to a terrorist also. So national security could also be at stake. And yeah, so I think I'll sum it up that way. Given an opportunity, we could actually discuss more on these related aspects, also the case laws that I did not mention on right to be forgotten, as well as on right to privacy, the various aspects of right to privacy that I was talking about. We will probably have some other time if this was interesting, if the university permits that. Okay, so any questions, any comments, and any observations, please do point out, please do ask. Thank you.
Anybody wishing to ask questions to Dr. Sandeep, sir, please either drop it in the chat box or please unmute yourself and ask the question.
Sir, I have a question for you.
Yeah, hi.
Hi, this is Sandeep here from third year LLB. Sir,
Okay.
I'm not aware if you are aware about a fiasco between Bharadwaj Speaks and Governor Swaraj.
Come
This was
again?
in
The
relation
fiasco between?
between Bharadwaj Speaks. Yeah, this is a
Okay.
Twitter account.
Okay. Okay.
Bharadwaj Speaks and
Okay.
Governor Swaraj.
Okay.
Governor Swaraj was former governor of Mizoram and Assam, that area, and he was one of the mediators or negotiators.
Okay.
Who, like, recently there was one incident where, like, there was police being killed by people and people killing police in that area, and they were saying, like, they are mafia and so on and so forth. So here, Bharadwaj, what he does is, like, he
Police killing
puts
people as
all
I
the,
talk about the Nagaland incident or the Assam incident?
it was in the border. It was
Which
in the
border?
border
Okay. Oh
of
yeah,
Assam.
whatever. Yeah. Okay. Assam. Oh yeah. Okay. Okay. That's
Yeah.
regarding acquisition
So
of land. Okay. Yeah. Okay.
yeah. So in that there was some certain accords and peace which the governors of those times they did, and later
Right.
it was like, so all these were in public record, and all Bharadwaj did is, like, he just, like, brought it forth to the people who was following him.
Okay.
And here there was, like, a verbal like, a fight,
Exchange
or here,
between. Yeah.
yeah, I mean, in a gentleman wherein, like, the governor started, like, threatening him of IPCs, and, like, he was saying, like,
Right.
you are not supposed to disclose all these things.
Right.
But then, like, his defense was, like, all these things are already there in public
Public domain. Right.
forum, yeah, public domain. So I'm not revealing anything secret. If it is
Right.
not supposed to be in public domain, it should not be. I mean, if it is not, it's supposed to be secret, then it's not supposed to be in public domain.
Right.
So and then, like, he had to, like, now here then he Bharadwaj, like, he not Bharadwaj, the governor, like, pulls out details of Bharadwaj, his personal details, and, I know where you're staying, I know where you're doing, I know what you're doing, and all that. So that kind of he stoops himself that low. And then,
Right.
like, he also gives his explanation as to, listen, I was the main mediator over here, and then, like, you are not supposed to, like, you have no clue as to what all we had negotiated and what all we have promised, and because it's so complex, so you cannot just merely put down statements here saying that, this is what it is and this is what is that. You can't make
Right.
a statement out of it. So and then, like, there was a lot of threats to Bharadwaj, saying that, he will be put under he will be put into the jail and all that, and he, like, end of the day, like, he deleted the account and so on.
Right.
So can a governor, I mean a former governor, come on the Twitter and, like, put on I mean, like, that was a complete display of power, and it was like, Bharadwaj is just a common man. He's just like any one of us, and, like,
Right.
a former governor with so much of power, like, making a person, like, going and, like, delete his account just because he just, got out the truth in front of everyone. So what is your opinion about that, sir?
Okay.
And
I
he
was
was,
okay. Yeah.
yeah, this is with regards to, like, personal information which the governor leaked.
Right.
That too on Twitter.
Correct. Now I'll tell you something. When it comes to an academician who probably would be discussing aspects on national security, counter-terrorism laws, we don't have any kind of an anti-terrorism. We have we have acknowledged the fact that there is terrorism in this particular country. So anti-terrorism could be to ensure the fact that terrorism is kind of eroded completely. We only have counter-terrorism laws. It's just to counter the terrorism that is it. So things that would be coming from me would obviously be not that pro-governmental, not pro-executive. Why? Because ultimately at the end of the day, the government or the governor, in your case, government or the governor, when they come out to the public, when they express something, it's very, very, very difficult to prove that it was actually a personal comment and not the government commands. There's a huge difference between a personal comment and a government command. So when you actually talk about somebody expressing something in a Twitter account, that could be a very personal, comment or an observation. When any member of the government, when any member who is holding a constitutional post, or even otherwise, any member of the government who may not be always holding a constitutional post, when they public servants, when they actually come out in public, when they go into any social media accounts, and when they express something, it is obviously a kind of a governmental or an executive command. All right, that has got the sanctions of law, not in terms of punishments, in terms of validity. Now, when you were asking this particular question, I was just referring to the same set of slides that are being shared in connection to internet shutdown. So in the slides that were presented before all of you, there was one particular slide, that is slide number 31, which has correctly identified, not my own observation though, which has correctly identified the government's justification in going for internet shutdowns. One of the justifications, or probably the only justification in most of the cases that has been granted, that has been given by the government, I'll read it out to you, Sandeep, okay, if you're still listening. Okay, the reason is this. Provocative material on social media could misguide the general public and result in a law and order situation. Did you get it, Sandeep, what I just said, the quote that I just used right now? This is the exact statement made by the government as a justification before Anuradha Basin's case and in other judgments also, to actually go for restricting somebody's access to internet, basically. Social media, part of internet, right? So now ultimately the problem is, it is so easy for the government to justify their actions based on one ground. And that ground is nothing but public order. It's very easy for them to justify. So if anybody's statement could actually be a threat to public order, is something that they could easily establish, because going against that burden of proving that, it probably would not even cost anybody's lives. It would not cause any kind of injury. It would not cause a public disorder. That burden is so much. So it's kind of really easy for the government to do it. When it gets political, if you want me to get political, my answer is a big no. The governor shouldn't have actually misused his constitutional authority to do that. But I was not aware of this particular incident. But to tell you very frankly, it's just because of this. The government's tool in their hands is this particular aspect of public order. So if the government reasonably believes, if they have an apprehension that the public order would be at stake, then the government is free to do it, which is as sanctioned by even the criminal statutes in this particular country. So IT Act has got no connection to this, because it's the criminal law statutes and the constitution that would come into play. So I would personally, on a subjective note, say that was inappropriate. But whether the law facilitates it, yes, the law facilitates that. And that is the reason why it need not be in the virtual world. It could be in the real world as well. Even a sign, even a visible representation, even a speech, even a written pamphlet. If they think that it actually causes some kind of a public disorder, they could do that. I'll tell you something else also. It's not very difficult, Sandeep, now that you've asked this thing, it's not very difficult for a simple Twitter or a simple tweet or a Facebook post to constitute an offense under the counterterrorism legislations also. Now, I did not say that would constitute terrorism. Did I say that? No. I just said it is not very difficult for that to constitute an offense under any counterterrorism legislation. I'll give an example. Sandeep, don't you think that you have a right to an association, right to form an association? Don't you think so?
Yes, sir.
Imagine that the same post was done by you, being seconded, supported by a group of 5 other persons, or maybe 6 or 7 or 2 or 3 or 10 or 100 persons. Don't you think that is also an association, good or bad? Objective being good or bad, that's an association formed in the cyberspace, right?
Yes, sir.
It need not be considered at all as something that is a terrorist activity, but this particular association with an objective, with a motive, with an ulterior motive of causing some kind of a disruption in public order, could easily be categorized as an unlawful association under UAPA. Did you understand? No, we are not talking about IPC unlawful assembly here. We are talking about UAP unlawful association. So the problem here is it depends on whether the government can substantiate at least prima facie that this would actually cause some kind of a public disorder. If they do that, you become an accused. Then you have the next stages. Proving yourself not guilty, that's a different thing. So to make somebody an accused in cyberspace with the help of Twitter or something, yes. You're talking about one particular layman. Talk about some other things that have happened on account of climate change advocacy, on account of tweets that tweets that motivated the high courts and Supreme Courts to take up the bail orders of persons who were arrested and languishing in jails because of that Bhima Koregaon matter. Talk about the tweets that prompted the judiciary to take up the matter. That those who tweeted, they had to suffer. Got it? So making somebody an accused, subjective opinion is a big no, big emphatic no. But as of now, the law facilitates that. So I am not at all a person who actually says that right to privacy is something that is guaranteed, right to freedom of speech and expression is something that is guaranteed in India 100%. Absolute rights are not there. Over and above the restrictions that are there in the statutes and the constitution, we could see all those things happening in this particular country, and that is only because it gets political. The answer to the question also could be very smooth. The which all policies have been challenged, which political party's affiliation. Governor should not be like that, but which political party's affiliation could be attributed to that particular constitutional post. The answer would be simple. We need not go there. I'm not going to ask you that particular question also, because there could be any kind of political supporters also, including me. You never know, right? But subjective opinion would be a big no. But objectively assessing it, we do have provisions that would permit the government to probably, I'll use this word, to threaten the public, any layman, to threaten the public from saying, in saying that this would actually disturb the public order. That's the reason why, you're considered as an accused. So you would be considered as an accused. Misleading the public, misguiding the public. You might be guiding the public, but the government says misguiding the public, and which would actually result in a law and order situation. That's a trick that they use. That's a defense that they use. All right. And I hope you might have understood the other tweets that I was referring to. It's so political that I did not want to use anybody's names. Persons who were arrested from Bangalore without a transit remand, without a transit warrant, they were being, all that, right? I don't have to go to that. So that's the place we live in. And there are persons, when I take these sessions on classes, there are actually persons who actually say that you cannot actually dilute national security, so right to privacy need not be there. So that should be respected as well. And they are not speaking pro-governmental. No, always. They're speaking about the fact that maybe true. I'm not really sure as to whether I kind of gave an answer that you were expecting, but this is something that I think about. Preventing it, not possible. Not possible. Fighting it in a court of law, that is possible. One of the amendments that's been suggested by the Joint Parliamentary Committee to the PDP bill is this. Section 35 and 36, leave that. We don't need Section 35 and 36. Because if Section 35 and 36 are there, the problem is the government could just say that this act is not applicable to them, to its own agencies. So ultimately the JPC said, okay, let's have 35 and 36, but give one thing in clear, one thing you make it explicit in the PDP bill. What is that? 35 and 36 says that government need not go with this particular application of this act, but they would be restricting other person's privacy only in a just, fair and reasonable manner. Think about this thing. Do you want that to be specifically mentioned? It's already granted. It's already granted. Do you want that to be specifically mentioned in the act? But that's a JPC recommendation. And now that is in the session, they'll be debating on this. If it is there, if it is not there, it's already granted under Article 21, right? Procedure established by, it's already there. I did not get that particular recommendation. So yeah, these kind of incidents could still happen. But thank you so much for the question. I kind of saw a few questions in.
Yes,
chat.
sir. We
Just
have
a
2 questions.
Pegasus case as individual right to privacy. Want to know your opinion about government involving foreign spyware firm to invade citizens' privacy. I'm so sorry that I did not include that. What is Sujitra ma'am? Okay. Now see, okay. Yeah, okay. Now the thing is, when it comes to Pegasus, I'll tell you something which happened quite late. Everybody knows spying on somebody is not at all a great tool for the government. You probably could call that surveillance, but it's not surveillance. Who asked me that question? What's the name? Where is
Suchitra.
Yeah, Sujitra. Sujitra, what do you think about? Yeah, if you're interested in participating, otherwise it's fine. What do you think about the Supreme Court intervening, appointing a committee, appointing a commission, and asking that particular commission to identify whether spying with the help of Pegasus has in fact been done? What's your opinion? If you want to write in the chat, that's fine. If you think it's a good opinion, please write it's a good thing. If it's a bad opinion, please write it's a bad opinion. So in the meantime, while you type that, I'll just continue to talk on Pegasus. Now, see, thing is, Pegasus, the NSA group of Israel, they have already confessed to the fact that they do give it only to government or any agencies authorized by the government. And if it has been put to use, it should be either because of a judicial order, it should either be because of a government order to the particular government agency, asking them to utilize this particular software. Now, the problem is it's obviously a bad thing because it violates right to privacy. What I did to understand this particular scenario was I went and then checked the guidelines issued by NSA on Pegasus and other softwares. So their original, I think I have that, their original idea and writings on what they intend to do with Pegasus. So that's what I did. So my objective was to actually find out what they've actually intended. So they've explicitly confessed the fact that they give it only to the government agencies. And there is a reason why they do it. Several governments have succeeded in combating drug trafficking, terrorist activities with the help of Pegasus. Sujitra, if you know that there is something called as NatGrid, NATGRID in India. After 2008, after the Mumbai 2008 blast and all that, what terrorist attack, what India realized was there's this particular person by name. What's the name? Somebody help me. Pakistan-born US terrorist. What's his name? David Coleman Headley, if I'm right, right? If I'm wrong, just correct me.
Yes,
Okay?
sir, that's right.
Yeah.
That's
So
the
this,
right
yeah,
name.
thank you so much, Sandeep. Yeah, so this particular person has traveled to India many a times, right? This part, yes, Sujitra, yes, I think I'm not really sure as whether you're a student or faculty. Sujitra, ma'am, that's absolutely right. If we have to actually organize a particular seminar on national security, there are several procedures that we need to have. You require permissions and all that. So yes, even academics, I use the term terrorist like 5 or 10 times here. Be rest assured that the government would be using Section 16 of the Information Technology Act, intercepting, monitoring, and trying to decrypt this particular information. That's so normal. Of all the platforms, we're using Zoom. Of all the platforms, that itself is a threat to privacy, right? We're not using Google Meet. So it's there. So that's obviously there. Even before probably all of you getting this particular PPT slides of mine, others would have obviously introduced into this thing and got it. So that's there. That's something that's underlined, that's always there at the background. So what was I saying? Okay, yes. So when I kind of, yeah, this particular person traveled to India many times, and India realized the fact that we did not know the fact that this particular person had so much of planning, frequently travel to India, travel back. We are supposed to know that. Since then, we are trying to actually go for several measures. National Investigation Agency Act, NIA Act of 2008 is the best example. We went with so much of other counter-terrorism measures, but the states opposed it by saying that's against federalism, center intervening in the states' matters. We will not approve of that. So very recently, you all might have read a particular news saying that NatGrid is going to be functional. It is already functional is what people say. NatGrid is something where 21 governmental central agencies are coordinated together, whereby the central government, NIA, everybody can easily get the information. Say, for example, if Sandeep M.N, if myself, travels with the help of a metro, takes a particular normal train. I have this particular bank account. I've used this particular debit account here. My credit card I've been using this particular shop. If the government is suspicious of my activity, the government thinks that I belong to either an unlawful association under UAPA or a terrorist, Section 15 UAPA, then this could actually be tracked. So various authorities would be tracking various things of mine that will be coordinated to the center. You talk about right to privacy, you don't talk about right to privacy there because you talk about national interest there. When this particular data gets leaked, That's the problem. You have these face IDs being taken by, going to be taken by the airports in India right now, which is a big problem right now. That is actually going to happen. Now the problem is, we talk about smart chain, we talk about blockchain contracts, we talk about smart contracts and all that. This, if it is leaked, that's going to be a massive threat to this particular country as such. Now, coming to the actual point, when I looked at the particular guidelines of this particular NSA group, not just on Pegasus, it is effective. I wouldn't say that it's not effective. It is effective in combating cartels, drug cartels, terrorist gangs, and all that. At the same time, do we have that much of what do you call that? Syndicates here, crime syndicates here? Do we have that? We have some legislations called as MACOCA. Have you heard about that? MACOCA, Maharashtra Control of Organized Crimes Act. Do we have that much of organized crimes in India? If it were there, every state would have had legislations. We have Maharashtra, we have Telangana, we have Karnataka. Very few states have these legislations to curb unorganized crimes. Not every states have that. If that is not there, we don't talk about cartels and unorganized crimes or crime syndicates. Why have Pegasus? Is the first question to those who says it is useful. Okay. Second point is, NSA does not have any kind of accountability or responsibility over its use by any other government agency. If you carefully read that particular thing, if you want, I can just send you that particular link also to Vidya ma'am. I have that in another set of slides. I'll just check whether it is there. I'll just, while speaking, I'll check that. Just a second. Yeah, when you talk about Pegasus, the problem is their regulations, their guidelines specifically says that they are only bound by the international conventions such as UDHR. They are bound by, something called as Ruggie principles or United Nations Global Compact principles of 2011. Kind of, it's never binding. So that's something that I actually wanted to point out. Just a second, just give me 2 minutes, not 2 minutes, 1 minute. I'll just try to actually give you that particular thing. If not, I'll just send a mail. I had that somewhere. I'm not really sure as to where I've kept it. So sorry that I did not. Yeah, there's another judgment also, Subranshu Raut versus State of Odisha, where there was some problem in a relationship and the guy posted some pictures of personal private pictures of his former girlfriend, and the court unfortunately says that particular pictures, everything should be removed, but we don't know how that can be removed. So even there were instances where courts were in a dilemma regarding how to go about it. So just point out that additional one. I'm sure I'm not finding it. Is there in one of my slides I specifically mentioned? I'm sorry, I'll just take it next time, or I'll just send by mail. Which are the other questions that are there? Given the fact that, oh yeah, surveillance, that's there. One of the instances which we teach the students when we start from all these cases on right to privacy, what we say is, if there is a law that has permitted surveillance, say for example, domiciliary visits at night, what's the problem there? Is domiciliary visits at night restricting somebody's right to movement? Supreme Court initially said, no. If the police come to you only at night, in the morning you can just walk around. Right, only at night time you cannot walk around. So that's not a restriction on movement. Whether it is there and that's a huge threat. That's a problem. I do agree. Spyware can also implant false documents to our devices. Yeah, that's there. One of the defenses that's been raised by persons, including Sudha Bharadwaj, who are all accused of Sten Swami, who are all accused of who are accused in Bhima Koregan violence. They have given this particular defense before the courts. They have actually given this particular defense, saying that it was not something that they did. They did not share any particular files. They did not have these particular files in their personal computers or computer system or a computer source as such. Basically, everything was implanted with the help of other softwares. There's other applications is what they have countered. The problem is that has got not strict connection with the Information Technology Act alone. There are specific statutes in India which authorizes a maximum period of detention even up to 1 year. The RPC says 60 or 90 days. After that, default bail should be given. That may be extended up to 180 days. That may be extended up to 1 year also. So that is the reason why they're all languishing in jails. Getting even otherwise bail provisions. Please, if somebody, if it is possible, please read section 43 D, section 43 5D. UAP, you'll understand how difficult it is to get paid. Just like NDPS, just like the previous portal, there are differences between UAP and that, but still it is very, very, very. So there's other reasons. Those are the reasons. Sujitra ma'am, I'll definitely be sharing you that particular title which you need to actually, yeah.
Thank you so much, sir.